Thank you, Paul, for your hyperbole. I'm certainly blessed both to be at this law school and to hold the Spies chair. I did not have the privilege of knowing Dean Spies personally, but I know he was a revered figure here and that we all continue to benefit from his stewardship of the law school. I'm honored to hold a chair in his name. And I'm also very grateful to Julia Spies Dunstan and to the former occupant of the Spies chair, John Jeffries, for their leadership and generosity in helping to reconstitute the chair as a distinguished professorship. I fear that the result bears out a Newtonian principle, which is that the recent increase in the distinction of the chair's title offsets the recent decrease in the distinction of the chair's holder. But I comfort myself with the knowledge that the same could be said of any chair that John Jeffries had departed, so it is not just about me. I've spent the last few years working on a case book about statutory interpretation, so today I want to talk about a fundamental topic in that field, the relation between legislative intent and statutory meaning. That's a topic on which there has been a lot of extravagant rhetoric. In my view, though, the rhetoric has often reflected and reinforced confusions. You're probably familiar with some of the rhetoric. It is sometimes said, for instance, that the very concept of legislative intent is empty or has no meaning. Because legislatures are multi-member bodies, they don't have a single mind, they can't think or form intentions in the way that individuals do. As a result, any notion of legislative intent is bound to be something of a construct. Even if it's based on the actual intentions of individual members of the legislature, it requires some artificial method of combining those potentially disparate intentions to produce an aggregate intention that can be attributed to the legislature as a whole. To be plausible, moreover, that method of aggregation needs to take account of the complex internal rules of procedure of each house of the relevant legislature, which work differently with respect to different bills, but which are going to cause the views of some legislators and staffers to matter more than others. According to some, those complexities make the notion of legislative intent entirely fanciful. People who advocate the interpretive approach known as textualism often advance that criticism of legislative intent, and I consider myself a textualist of sorts. But I have to say that I find the textualists' rhetoric about the emptiness of legislative intent unconvincing and overstated. It is true that concepts of group intention are complicated and artificial, but it is not true that every possible method of constructing such intentions is just as good as every other possible method, and that the notion of legislative intent therefore has no determinate content. Despite the textualists' rhetoric, that point is not actually very controversial. Hardly anyone really doubts that the concept of legislative intent can be coherent. To take an extreme example, if all of a legislature's individual members share the same understanding of a bill that they're enacting, it surely would be natural to attribute that understanding to the group as a whole. When people say that the concept of legislative intent is incoherent, what they really mean is that as a factual matter, the conditions under which it is coherent to talk about collective legislative intent do not usually obtain. In other words, the claim is not so much conceptual as empirical. But even when recast as an empirical claim, the idea that it is usually impossible to talk about any sort of collective legislative intent still seems overstated to me. For one thing, the conditions under which it is coherent to talk about legislative intent probably don't require absolute unanimity. They don't require every member of the legislature to have exactly the same thing in mind. And even when the facts are such that the legislative intent on some point is not completely determinate, it can still be partially determinate. For a simple example, just suppose that a legislative chamber is considering a particular bill, and suppose that 2/3 of the legislators who have positions on the bill's meaning understand it to establish Directive A, while the remaining 1/3 understand it to establish Directive B. Depending on the chamber's procedural rules and the relative importance of the legislators in each group, we may not be able to conclude, in a non-arbitrary way, that the chamber as a whole intended to establish Directive A rather than Directive B. But we probably can say that the chamber did not intend to establish Directive X. In that negative sense, at least, it often will be coherent to speak of legislative intent. The kinds of intent that matter most to interpreters, moreover, may well be the kinds of intent on which legislators are most likely to have shared views. I'm not qualified to wax philosophical about what we mean by meaning, but I do want to distinguish between the meaning of a legal directive and the concrete applications of that directive to particular circumstances. People who attack the role of legislative intent in statutory interpretation sometimes blur that distinction. Take the famous attack that Max Radin published in the Harvard Law Review in 1930, which modern textualists continue to invoke. Radin identified meaning with application in a very strong sense. Indeed, after defining the concept of ambiguity to refer to statements that have two possible meanings, Radin asserted that statutes are, quote, almost by definition ambiguous, close quote, because virtually all statutes apply to more than one unique situation. In other words, Radin thought that a statute with multiple applications had multiple meanings. His attack on references to legislative intent grew out of that idea. As he noted, in legislative bodies that consist of several hundred people, it is extraordinarily unlikely that each member will have exactly the same determinate situations in mind as possible reductions of a given statutory directive. And that's certainly true. Members of the legislature that enacts a statute will not all have exactly the same illustrative applications in mind when they act. According to Radin, it followed, quote, that the intention of the legislature is undiscoverable in any real sense. But that doesn't automatically follow at all. If you and I are both legislators, and we both vote for a bill establishing a speed limit of 65 miles per hour, we may well have the same understanding of the bill's meaning, even if you have a picture in mind of a policeman pulling over a speeding Toyota on a certain day, and I have a picture in mind of a policeman pulling over a speeding Ford on a different day. Admittedly, the intended meaning of a statutory directive does have some relationship, which I haven't yet fully worked out in my own mind, to each individual legislator's expectations about the likely application of that directive. At a minimum, those expectations are relevant to the votes that the legislators cast. When legislators are deciding whether to support or oppose a particular formulation of a bill, they are likely to think about how that formulation would apply to certain paradigm cases that come to their minds. As Radin suggested, moreover, the paradigm cases that one legislator envisions may well differ from the paradigm cases that another legislator envisions, but it doesn't automatically follow that these two different legislators have different understandings of the bill's meaning. To use a geometric analogy, if we think of each application of a statutory directive as a dot on a graph, we might think of the directive itself as a line that connects the dots. Even if two different legislators have thought up two different sets of dots, it is certainly possible that both sets lie on the same line. In other words, the mere fact that different legislators are thinking of different possible applications of the statute does not necessarily mean that they have different understandings of the statute's meaning. I don't want to overstate that point. Even on matters that individual legislators consider during the legislative process, the statute that they enact will not always have a single intended meaning that can properly be attributed to the legislature as a whole. And on matters that nobody foresaw at the time of enactment, the notion of intended meaning may often be indeterminate, or at least partially indeterminate. But by conflating applications with meaning, Radin may well have exaggerated the circumstances in which the concept of intended meaning is indeed incoherent. At any rate, the fact that courts have to apply statutes to situations that didn't specifically occur to members of the enacting legislature, or the fact that different legislators had different mental images of the circumstances in which their directive would apply, doesn't automatically prevent us from speaking of the directive's intended meaning. Just as the distinction between meaning and application helps limit some of Max Radin's criticisms of the concept of legislative intent, so the distinction between actual intentions and hypothesized intentions helps limit some of Frank Easterbrook's criticisms of that concept. In a famous article that he published when he was a law professor at Chicago, Judge Easterbrook took aim at the interpretive approach that is sometimes called imaginative reconstruction. Under that approach, When interpreters are asked to apply a statute to a situation that members of the enacting legislature did not specifically anticipate, and that differs in some material way from the situations that they did anticipate, interpreters should try to imagine how the enacting legislature would have worded the statute if legislatures had anticipated this situation. What do the decisions that the statute is known to reflect, and other available information about the policy preferences of members of the enacting legislature, suggest that they would have wanted courts to do with respect to this new situation? Fans of this approach often associate it with the search for legislative intent. But Judge Easterbrook is not a fan. His article argued that the discoveries of public choice theory have undermined the logic behind imaginative reconstruction and have shown that its search for legislative intent is all but hopeless. When Easterbrook mentioned public choice theory in this context, he was referring to the fact that groups do not think in the way that individuals do, and that choices made by a group therefore won't always seem consistent when judged by the standards that we might use to assess choices made by an individual. For a familiar example, imagine that a unicameral legislature has to decide how to spend some money, and it is choosing among 3 different possible programs: Program A, Program B, and Program C. Suppose that one block of legislators prefers Program A to Program B, and Program B to Program C. Another block of legislators also prefers Program B to Program C, but prefers Program C to Program A, and a third block prefers C to A and A to B. Each individual legislator's set of preferences is perfectly consistent, but that is not necessarily true of the legislature as a whole. If the blocks are roughly the same size, the legislature as a whole seems to favor A over B and B over C, but it also seems to favor C over A. If the legislature's procedures call for holding 2 pairwise votes to figure out which program to fund, then the decision that the legislature reaches may well depend upon the order in which the alternatives are considered. As a result, even if we somehow have absolutely perfect information about each individual legislator's policy preferences, we still won't be able to predict what the legislature as a group will decide unless we also know the order in which the votes will be held. Judge Easterbrook drew the following lesson: decisions that a particular legislature is known to have reached are not a sound foundation for conclusions about, quote, what the legislature would have done with a proposal it did not consider in fact. After all, what the legislature would have done might well have depended on the order in which it considered the alternatives, which isn't the sort of thing that people outside the legislature can readily predict. According to Judge Easterbrook, then, it is impossible to reason from one or more sections of a statute to a problem not resolved. Judge Easterbrook cast that conclusion as an attack on the concept of legislative intent in general. In his words, quote, because legislatures comprise many members, they do not have intents or designs, hidden yet discoverable. Each member may or may not have a design. The body as a whole, however, has only outcomes, close quote. But Judge Easterbrook's argument wasn't really about legislative intent in general. Instead, it was an attack on ad hoc uses of imaginative reconstruction to try to identify the legislature's hypothetical intent on policy proposals that the legislature did not actually consider. Judge Easterbrook didn't purport to establish that legislatures as groups never have any relevant collective intentions about the meaning of provisions that they do consider and enact. Return to the example about deciding whether to fund Program A, Program B, or Program C. It is true that unless and until a funding proposal actually goes through the legislative process, people outside the legislature might be hard-pressed to predict what the legislature will do. There are lots of different ways in which the available money might be allocated, and the choice that the legislature makes will depend on who controls its agenda and what sorts of deals are permitted. But if the legislature ultimately enacts a statute giving $5 million to Program C, $3 million to Program B, and $2 million to Program C, we may well be able to speak coherently of the intended meaning of that statute. That is, the meaning that members of the enacting legislature collectively understood the statute to convey and collectively intended it to convey. Justice Scalia has launched a different attack on references to legislative intent in statutory interpretation. He has suggested that even in circumstances where the concept of legislative intent is coherent, it is not actually relevant. The point of statutory interpretation is to determine, quote, the objective indication of the words rather than the intent of the legislature. I agree with Justice Scalia that those two concepts are distinct, but they are not hermetically sealed from each other. The rules and techniques that we use to determine the meaning of statutory language, or what Justice Scalia calls the objective indication of the words, are designed in large part to promote successful communication from legislatures to interpreters, so that what members of the enacting legislature collectively intended a statute to mean tends to correlate with what subsequent interpreters understand it to mean. Outside of the law, that is certainly one of the functions of language. More than 300 years ago, John Locke, who made contributions to the philosophy of language as well as to political philosophy, described words as devices for the communication of ideas, so that, quote, those invisible ideas which a person's thoughts are made up of might be made known to others. Admittedly, that's not the only function of language. Words can prompt ideas in the reader's mind that were not present in the author's mind, and some forms of literary interpretation revel in that possibility. But much of interpretation is about communication, about trying to figure out what a particular statement or text was intended to convey. Many familiar principles of statutory interpretation reflect that goal. For instance, when courts have to interpret a statute that contains an obvious typo, even Justice Scalia agrees that they should read the statute to mean what it would say if proofreaders had caught and fixed the typo. As Larry Alexander and my colleague Sai Prakash have argued, that's obviously a way of making meaning track the legislature's communicative intent. So too are many other interpretive principles that come up more frequently in practice. Take the presumption against superfluity. Suppose that Section 1 of a particular statute seems ambiguous when considered in isolation. It might be understood to establish either Directive A or Directive B. But suppose that if Section 1 were read to establish Directive A, then Section 5 of the same statute would be superfluous. Interpreters commonly treat that fact as an argument in favor of the other reading of Section 1, the one that leaves some work for Section 5 to do. This principle is so familiar that we do not tend to think about its underlying logic. But when you think about it, the presumption against superfluity rests on an inference about legislative intent. The fact that the enacting legislature bothered to include Section 5 sheds some light on what members of the enacting legislature probably intended Section 1 to mean. And that information affects the meaning that interpreters themselves ascribe to Section 1. A lot of canons work that way. They encourage interpreters to read otherwise ambiguous statutory language in one way or another based on some other piece of information that bears on what members of the enacting legislature probably intended. For example, the presumption of consistent usage, which encourages interpreters to read a word in one provision in light of how the legislature used the same word elsewhere in the statute, is plainly designed to produce correlations between the meaning that courts ascribe to statutes and the meaning that members of the enacting legislature collectively intended to convey. The same is true of principles like eiusdem generis and noscitur a sociis, which tell interpreters that when they confront an otherwise ambiguous term in a statutory list, they should prefer readings that fit the pattern established by other terms in the list. There are many similar examples of intent-oriented canons. To the extent that courts use these canons to determine the meaning of statutory language, or what Justice Scalia calls the objective indication of the words, and to the extent that these canons are part of our interpretive system because of their tendency to align with legislative intent, it is hard to maintain that legislative intent is irrelevant to statutory meaning. Some other canons are linked to legislative intent in a different way. Take what Justice Kennedy has called implied limitation rules, canons that favor reading certain predefined limitations into seemingly general statutory language, unless there's reason to believe that the enacting legislature specifically focused on the issue that the canon addresses, and really intended the statutory language to be just as general as it seems on its face. the presumption against extraterritoriality, which encourages interpreters to read geographic limits into seemingly universal statutory language, and the presumption against retroactivity, which encourages interpreters to infer certain types of temporal limits, are examples of implied limitation rules. Unlike the presumption against superfluity, these implied limitation rules are not necessarily about the conscious semantic intentions of members of the enacting legislature. Arguably, canons like the presumption against extraterritoriality and the presumption against retroactivity instead reflect a species of imaginative reconstruction. They single out certain recurring issues that legislators frequently gloss over, and they tell interpreters to assume that if members of the enacting legislature had consciously considered those issues, they probably would have favored the limitations that the canons reflect. Even on that account, though, these canons, too, are linked to the communicative intentions of the enacting legislature. The point of these canons is that even when a statute doesn't explicitly address its geographic or temporal reach, members of the enacting legislature probably did not really mean the language to be completely all-encompassing. That is why these implied limitation rules can be overcome by indications that members of the enacting legislature really did intend the statute to be just as universal as it seems on its face. So even these implied limitation rules, which encourage interpreters to read in limitations that do not appear in the words that the legislature enacted, are presumptions about what members of the enacting legislature intended those words to convey. I don't mean to claim that all canons are linked to some type of legislative intent. Some canons are purely normative. They don't purport to be designed to increase the correlation between the meanings that interpreters ascribe to statutory language and the meaning that members of the enacting legislature intended to communicate. By and large, though, the normative dimension of canons comes into play only after interpreters have exhausted their intent-oriented tools. Consider the rule of lenity, which tells courts to resolve ambiguities in penal provisions in the direction of leniency. Most scholars agree that the rule of lenity is purely normative. In keeping with that fact, though, mere superficial ambiguity in statutory language is not enough to trigger the rule of lenity. Instead, the rule of lenity matters only when there is end-stage ambiguity, when intractable ambiguity remains even after the court has used all its tools for figuring out what members of the enacting legislature probably intended. As the Supreme Court has said in case after case, quote, "The rule of lenity applies only if, after seizing everything from which aid can be derived, we can make no more than a guess as to what Congress intended." I think that's true of normative canons in general. For the most part, interpretive principles that have no connection to the search for legislative intent enter the picture only at the end of the process if the permissible sources of information about the enacting legislature's likely intent have run out without identifying a single best interpretation. That shouldn't come as a surprise in a democracy like ours, in which the policy-making authority of the legislature is usually superior to the policy-making authority of the courts. To the extent that courts are supposed to act as faithful agents of the legislature within the limits established by the Constitution, it makes sense for the principles of interpretation that courts use to be geared, at least in part, toward capturing the intended meaning of statutory language on matters as to which such collective intentions really did exist. Of course, that's not the only goal that matters in our system of statutory interpretation. The interpretive principles that we tell courts and administrative agencies to use also reflect some other goals. For instance, many interpretive principles reflect the goal of enabling people outside the enacting legislature to have fair notice of the law's requirements. The people who are subject to the law, and the electorate as a whole, should have some ability to predict the meanings that courts and administrative agencies will ascribe to statutes. Another important goal is simply containing the costs of the interpretive process. Even if devoting unlimited resources to investigating legislative intent would help courts reach marginally more accurate decisions about the intended meaning of statutory language, no one thinks that we should devote all of society's resources to that task. But while capturing the intended meaning of statutory language, where genuine collective intentions do exist, is not the only goal that our system of statutory interpretation is designed to achieve, it is at least one of the goals that affects the content of that system, which in turn determines what Justice Scalia calls the objective indication of the words that the legislature enacts. To appreciate that point, just think about how lawyers and judges might evaluate a proposal to articulate and apply a new canon of statutory interpretation. If use of the canon would predictably widen the gap between the interpreted meaning, the meanings that courts ascribe to statutes, and the meanings that members of the enacting legislature collectively intended, and if the canon wouldn't make up for this problem by serving any of the other goals of statutory interpretation, most of us would probably oppose introducing this canon. Indeed, even if the canon would serve some of the other goals of statutory interpretation, if it would systematically drive courts away from the intended meaning of statutory language, many of us would still oppose introducing this canon. For instance, think about why standard principles of interpretation call for interpreting old statutes according to the vocabulary and drafting conventions that existed when the legislature enacted those statutes, rather than the vocabulary and drafting conventions that happen to exist today. Determining the meaning of old statutes according to present-day linguistic conventions might serve some of the other goals of statutory interpretation. It might be cheaper because we don't need to use historical research to figure out what the present-day conventions are, and it might even be better from the standpoint of notice because the people who are now subject to these statutes presumably know the present-day conventions better than they knew the past conventions. But standard doctrine nonetheless opposes using present-day conventions to decode old statutes because it would unacceptably widen the gap between what the old statutes were intended to mean and what they are interpreted to mean. Thus, while Justice Scalia is correct that meaning and intent are distinct concepts, his rhetoric exaggerates their independence. The techniques and principles that make up our system of statutory interpretation and that determine the meaning of statutory language are geared, at least in part, toward capturing the meaning that members of the enacting legislature intended to convey. That is not to say that every statute automatically means whatever members of the enacting legislature intended it to mean. There are at least two categories of reasons why the meaning that courts should and do ascribe to statutes will not always coincide with the meaning that members of the enacting legislature intended to convey, even on points as to which members of the enacting legislature did have a collective intent. First, as I've already indicated, minimizing gaps between interpreted and intended meaning is not the only goal of statutory interpretation. Other goals matter too, and the interpretive principles that they inspire will differ in some respects from what we would tell courts to do if we were interested solely in making meaning match intent. For instance, consider widely accepted limits on the sources of information that courts consider when interpreting statutes. At least in the federal system, and in most state systems too, courts typically refuse to base their interpretations of statutes on after-the-fact testimony about what happened in some markup session that was not transcribed, or on internal memos about what was said in some party caucus, or on other documents that were not available to the public when the statute took effect. Maybe we would exclude some of that information simply on grounds of unreliability as evidence of the legislature's genuine intentions, but concerns about notice probably lead us to exclude more such information than we would exclude if we were interested solely in the historical fact of what members of the enacting legislature had collectively intended. To the extent that our system of interpretation restricts the use of certain sources of information that would help interpreters ascertain legislative intent, but that are not sufficiently accessible to the public, the meaning that the system assigns to statutory language will not always match the enacting legislature's actual communicative intentions. So one reason for divergence between interpreted and intended meaning is simply that our system of interpretation is designed to serve some other goals, like notice or cost containment. The second reason for divergence between the interpreted meaning and the intended meaning of particular statutes is that many interpretive principles are relatively rule-like. Even if the sole goal of our system of interpretation were to maximize the overlap between interpreted meaning and intended meaning, collective legislative intent isn't the sort of thing that courts can detect with complete accuracy. Sometimes the best they'll be able to do is to play the odds, to apply interpretive principles that usually guide courts toward the intended meaning of statutory language, where intended meaning does exist, but that are not accurate for each and every statute. Take the presumption against superfluity. Maybe it's an accurate guide to intended meaning 8 or 9 times out of 10, but it is not always accurate. Still, unless we can develop some sub-rule that distinguishes the circumstances in which the presumption is accurate from the circumstances in which it is not accurate, we might well tell courts to apply the presumption across the board on the theory that the presumption improves the accuracy of their assessments of legislative intent more often than it leads them astray. The same point applies more generally. Even when it is coherent to speak of a legislature as having had a collective intent on some question of statutory meaning, no method of ascertaining that intent will be perfectly accurate. While canons and other rule-like principles of interpretation are blunt and overbroad, totality of the circumstances judgments made without the guidance of rules won't be perfect either. And there are likely to be some issues on which courts will reach more accurate assessments of legislative intent in the aggregate if they accept the discipline of rules. To the extent that our system of interpretation does tell interpreters to take a rule-like approach, moreover, the meaning that the system associates with particular statutes will sometimes differ from what members of the enacting legislature collectively intended those particular statutes to communicate. But the fact that meaning and intent can diverge for individual statutes does not prove that the interpretive principles that determine meaning are unconcerned with intent. To the contrary, I think it's clear that one of the primary goals of our system of statutory interpretation is to produce correlations between interpreted meaning and intended meaning. So far, I have managed to talk about the relation between legislative intent and statutory meaning without mentioning the issue that is usually central to such discussions, whether the sources of information that our system of interpretation lets interpreters consult and on which they might base inferences about legislative intent should include the legislative history of the statute that they are interpreting. Everyone acknowledges that when interpreters have to ascribe meaning to a particular statutory provision, it is perfectly appropriate for them to consider some categories of extrinsic information that may help them identify the legal directive that members of the enacting legislature collectively intended to establish. Those uncontroversial sources of information include other provisions of the same statute, related statutes enacted around the same time, the public history of the times, what dictionaries and other sources tell us about the linguistic conventions of the time of enactment, and more. Equally uncontroversially, our system of interpretation also tells interpreters not to take account of certain other sources of information, after-the-fact testimony from legislators who participated in the process, secret records of markup sessions, and the like. But debates rage about how to classify a statute's publicly available legislative history, including the committee reports that were generated during the legislative process and the transcripts of debates that appear in the congressional record. The basic question is this: just as interpreters might resolve superficial ambiguities in a statute in light of other contemporaneous statutes or the public history of the times, should they also resolve superficial ambiguities in light of the publicly available legislative history? Or are there reasons to put that information off limits so that the meaning of a statute never depends on what appears in the committee reports or the transcripts of legislative debates that are published in the congressional record? Despite all the ink that has been spilled on that question, I have to say that I do not care deeply about the answer. To be sure, I am glad that courts have retreated from the aggressive uses of legislative history that were common in the 1960s and 1970s. Because our system of separated powers deliberately insulates courts from the legislature, most judges and their law clerks probably are not very sophisticated consumers of legislative history. As a result, even if the sole goal of interpretation were to maximize the correlation between interpreted and intended meaning, we should not expect courts to draw especially accurate inferences about collective legislative intent from the scattered passages of legislative history that litigants invoke. I share the now widespread view that when statutory language otherwise seems unambiguous, inviting courts to ascribe a different meaning to that language on the basis of statements in the legislative history is likely to introduce more errors about legislative intent than it avoids, and hence to widen the gap between interpreted and intended meaning. Even when statutory language seems ambiguous, I could perhaps be persuaded that research into legislative history, at least when it goes beyond learning the basic drafting history and reading the relevant committee reports, is likely to cost society more than it is worth. But while I'm open to the idea that courts shouldn't consult much legislative history, a lot of the common arguments for that idea strike me as seriously flawed. For instance, many modern textualists say that legislative history is irrelevant as a matter of principle. The information that it provides is just about the subjective intentions of members of the enacting legislature, and the point of statutory interpretation is instead to identify the objective meaning of the words that the legislature enacted. Justice Scalia, for one, writes as if that point is dispositive. He suggests that his opposition to the use of legislative history in statutory interpretation flows inevitably from his view, quote, that the objective indication of the words, rather than the intent of the legislature, is what constitutes the law, close quote. That's powerful rhetoric, but I want to persuade you that it is not itself an independent argument against the use of legislative history in statutory interpretation. It is entirely parasitic on the existence of other reasons for putting legislative history off limits. What Justice Scalia calls the objective meaning of statutory language is the meaning that an appropriately informed reader, applying the proper principles of interpretation to the data that he is allowed to consider, would ascribe to the words that the legislature enacted. But as I've already said, it is entirely possible for the principles of interpretation that determine this meaning to pay attention to a type of legislative intent, the communicative intent that a reasonable person would impute to the enacting legislature on the basis of the information that our system permits interpreters to consider. Justice Scalia acknowledges as much. While he says that courts, quote, do not really look for subjective legislative intent, close quote, he concedes that they do and should look for what he calls, quote, a sort of objectified intent, the intent that a reasonable person would gather from the text of the law, placed alongside the remainder of the corpus juris. Thus, he has quoted approvingly the following formulation of what courts are trying to do. The primary object of all rules for interpreting statutes is to ascertain the meaning which the subject is authorized to understand the legislature intended. Justice Scalia further acknowledges that the applicable principles of interpretation can make reference to various sources of information beyond the text of the provision being interpreted that bear on what members of the enacting legislature intended to communicate. For instance, Justice Scalia has read the words of one statute in light of how members of the same legislature used the same words in another statute that they had enacted a week earlier. Likewise, he seems willing to let interpreters consider what he calls the historical context of a statute, including information about the problems that the statute apparently was designed to address. And of course, he invites reliance upon information about the linguistic conventions of the time of enactment, as revealed in dictionaries and usage manuals of the day. Again, Justice Scalia is perfectly happy to associate the objective meaning of statutory language with what all this extra textual information leads a reasonable reader to believe the members of the enacting legislature intended to communicate. Nothing in the framework that I've just described requires us to exclude legislative history from the information that a reasonable reader is expected to consider when determining the meaning of statutory language. To the contrary, it would be perfectly logical to treat the legislative history that was publicly available at the time of enactment as part of what Justice Scalia calls the public history of the times. And if we did so, then what Justice Scalia calls the objective meaning of statutory language would reflect the inferences that the applicable principles of interpretation allow readers to draw from the publicly available legislative history, no less than from the other permissible sources of information. Of course, that might be a bad idea. Justice Scalia has advanced other, more practical reasons against letting interpreters consult legislative history, such as the argument that judges tend to misuse it, or that ordinary people don't have enough notice of what it contains, or that research into legislative history is too expensive. But those arguments, not the adjective objective, are the real crux of Justice Scalia's position. Legislative history is irrelevant to what Justice Scalia calls the objective meaning of statutory language, not because that meaning is objective, but because Justice Scalia has other reasons for excluding legislative history from the relevant information base, the data that the appropriately informed reader should be presumed to know and on which the applicable principles of interpretation operate. Let me close with a puzzle. If I am right that our system of interpretation is indeed designed to produce matches between interpreted and intended meaning, why do so many smart textualists speak as they do? Why do they vociferously deny the relevance of legislative intent to statutory interpretation? The answer, I think, relates to their support for rule-like principles of interpretation as a means of keeping costs under control, providing notice, and establishing a background for successful communication from legislatures to courts. Justice Scalia and other textualists emphasize the need for interpreters to apply stable and predictable rules. But as Fred Schauer has explained, rules tend to be opaque about their purposes, about their rationales. Once rule-like principles of interpretation are in place, the judges who apply them do not always have to recur to the underlying purposes of the rules. Instead of trying to figure out what will best advance those purposes in each individual case, they're simply supposed to apply the rules. In my view, that is why some modern-day textualists speak as if our system of interpretation does not entail a search for legislative intent. When they are applying the rules of interpretation that they favor, textualist judges do not need to frame their approach to each individual case in terms of the legislature's likely intent. But they shouldn't forget that one of the purposes of the overall system, one of the goals that determines the content of the rules that they are applying, is to increase the likelihood that the directives that courts ascribe to statutes will resemble the directives that members of the enacting legislature understood themselves to be establishing. Even if textualists are correct, the judges in individual cases shouldn't make certain kinds of ad hoc inquiries into legislative intent. Textualists cannot plausibly argue that legislative intent is irrelevant to the overall project of statutory interpretation. Thank you for your attention, and thank you for helping to make the University of Virginia such a wonderful home for Liz and me over the past 12 or 13 years. I think there's probably...